Hello and welcome to another episode of Legally Speaking, where we talk about contemporary legal issues which impact business. Today, we are going to discuss the judgment rendered by the Supreme Court of India last week on 15th of January 2026 in the matter of Authority on Advance Ruling versus Tiger Global Holdings. Joining me today is our eminent tax expert and head of our direct tax practice, Mr. Shahid Khan, and who is also a former member of CBDT. Uh, a warm welcome to you, Mr. Khan.
Thank
I'm
you.
also joined by our tax partner, Amit Shrivastava, who also has considerable experience in handling complex tax matters and legal disputes. Welcome, Amit,
Thank you.
to this.
Thank you so much.
So we have lots to cover. So let me start straight away with brief facts of the matter before I hand it over to our expert panel. So very briefly, the facts of the case are Tiger Global International Holdings, and there are three entities. These companies were incorporated under laws of Mauritius. These companies had obtained the global business license uh, under the Mauritius laws, and they had also obtained the tax residency certificate issued by the concerned Mauritius authority. Now, these companies, and in our discussions, we may refer to them as Mauritius entities or the SSEs, they invested in Flipkart Singapore Private Limited, company incorporated in Singapore, and Flipkart Singapore, in turn, had made investments in various entities in India. Um, Sometimes between 2011 and 2015, all these investments were carried out. By transpired was sometimes around 2018. There was a talk as part of a global transaction involving Walmart. It was proposed that the Mauritius companies would sell their shares to a Luxembourg entity. So, in relation to that, what the SSCs did, they approached the Indian tax authorities under Section 197 of the Income Tax Act, seeking a certification of nil withholding prior to the consummation of the transaction. The tax authorities, Indian tax authorities, informed the SSCs that they would not be eligible to avail the benefits under the Indo Mauritius Treaty on account of the fact that the tax authorities held or observed that these entities were not independent in their decision making. And as was described, the head and the brain of these entities were somewhere else. Mauritius entities thereafter approached the authority for advance ruling, and the authority held prima facie that this was a design, the transaction or the whole setup was a design for avoidance of income tax, and therefore uh, declined to issue the certificate. Now, this order was challenged by the Mauritius entities before the Delhi High Court, which quashed the ruling of the authority for the ruling that was given by the authority for advance ruling, and held that the Mauritius entities were entitled to the treaty benefits. Against this order, the revenue went on challenge before the Supreme Court. And that's the judgment that we are going to talk about today. So, to begin with, you, Mr. Khan, tell us briefly what are your thoughts in respect of this Tiger Global case, which, as you know already, has sent ripple waves amongst tax planners, investment advisors, and particularly those who are involved in international structuring. So, what are your thoughts, sir?
Thank you, Raj, for laying out the factual background. Before we enter into this discussion, let me say generally that is a very important deadline. It's virtually recast the entire tax jurisprudence in respect of Mauritius entities post introduction of GAR and post the amendment to the tax treaty in 2016. So in that sense, it is going to apply to a number of cases, and the court has gone at great length in setting out various factors because of which it says that these entities will not be eligible for the benefits of the India Mauritius Treaty. But let me also put a caveat on this. See, this matter went to the Supreme Court from authority for advance ruling. In the provisions relating to advance ruling, there is a requirement that the AR have to first satisfy itself prima facie that the transaction is not meant as a tax avoidance device. At that stage, the authority went into considerable detail on the factual part of it and ultimately ruled that it is a tax avoidance device and it is not eligible to the grant of ruling by the AR. Now, AR ruling is in parallel to assessments. So this and the entire dispute, our entire legal proceeding before the High Court and Supreme Court have arisen from that ruling of AR, where they are saying that this is the prima facie case of tax avoidance. So nobody has given as yet any authoritative judgment on any final judgment on whether it's a tax avoidance device or not, because they were the court itself, the Supreme Court also says that at the entries level, this is not admissible for a decision by AR. Now, please note that the proceedings before AR are in parallel to assessment proceedings. Now, if AR had declined to intervene, then also the taxpayer could have gone to the tax department and filed a return. So that has not happened. Therefore, this is a decision on prima facie facts whether the application for AR was admissible or not admissible.
Thank you for that clarification. And I think you make a very interesting and important point that this is a prima facie case. It's not that a final ruling has been rendered. Of course, there are certain concerns, and we will address that during the course of our discussion. But before we reach there, let me ask Amit also. Amit, briefly, what do you feel? What are your key takeaways from this judgment?
Thank you. I totally agree with Mr. Khan on this. Actually, the scope of inquiry before the Supreme Court and the question framed by it was only related to application of Section 245R proviso, where the authority was basically analyzing whether the this transaction prima facie is a avoidance arrangement or not. But what they have done, they are basically their analysis of the Supreme Court order is basically in such a tone and tenor that it appears to be a final conclusion on the matter. So that, according to me, is going to open a Pandora box, and basically it's going to be litigated uh, on number of cases.
Fair enough. Uh, and I think this whole issue about uh, possibility of future litigation, opening up of Pandora's box, is something which has already been expressed by the stakeholders, and we will obviously need to be mindful of that. But before anything else, now let me jump to some of the key observations of the court and also what this implies for uh, not just this matter, but generally speaking, the law on this whole issue. So, one of the key things which we have seen up until, say, Vodafone judgment, the TRC or the importance of TRC. TRC was almost like a sacrosanct document. So, Mr. Khan, would you say that that position has now been diluted? Where do we stand today?
Right. But before I reply to your question on TRC, let me clarify on the point that Amit was making. Now, this judgment, of course, discusses in great detail the legal issue. Now, the decision of the Supreme Court on legal issues is final. The decision on factual issues, whether on the in the purview of legal principles set out by the court, the facts of this case will be such as establish an avoidance arrangement. That is prima facie open. So the decision on fact is prima facie, but the legal principles that they have enunciated are specific and binding on all future courts. Now
Okay.
coming back to TRC, if you go into the history of this matter, TRC was brought in by a circular of the government of the CBDT, which was 789. I mean, the famous 789 circular, which was issued in the year 2000, where they said that TRC will be a sufficient proof of residence as well as beneficial ownership of the Mauritian. So the issue was that the benefits of the treaty, as it then stood, will be available to only to a Mauritian resident. How does one decide whether a particular entity is a Mauritian entity is a Mauritian resident or not? On that point, the CBDT said that any residency certificate issued by Mauritian Tax Authority will be conclusive of two things. One, that it is a genuine Mauritian resident, and two, that it is the beneficial owner of the shares in question. So that is where this thing started. But after 2000, a number of changes occurred in the legal background, on the legal side. First, of course, was the Vodafone judgment, which came in 2012, and thereafter the amendments to overcome the legal difficulties which arose from the Vodafone judgment, and the various amendments which came in, I think, by Finance Act 2012 and 2013. And then finally, the LOB clauses which were introduced in the treaty. So therefore, the department's position right through was that TRC is a valid document. TRC is the binding document, and the factual determination whether an entity is a resident or not will be on the basis of TRC. But what has happened is that the court in this case has taken note of two, three developments which have happened since then. One, of course, they have looked at Section 90, subsection 4, which was introduced, I think, in 2013, by which it was provided that the benefits of treaty will be available only on production of TRC. And then they say, then the court has said that TRC is a necessary document, but it is not a sufficient. And they have referred to Vodafone judgment, where also it was said that that in the case of fraud or sham transaction, it will be the revenue will be entitled to go behind the arrangement and find out the fact. So that was the position till this judgment, Tiger Global judgment. Now, what Tiger Global judgment says is that TRC is an evidence right, but it is not conclusive. It is necessary but not sufficient. And revenue has a right to go behind, in appropriate cases, to go behind that PRC and investigate and come to a determination whether the entity concerned is a genuine resident of Mauritius or not. So we are at the position now that TRC is not conclusive. TRC is a valid document, admissible document, but not a conclusive document.
No, I think that explanation is helpful because I think, at least from the SSE's side, before the Supreme Court and earlier also, a lot of reliance was placed on this Circular 789. So, in effect, what you are saying, one is, of course, that 789, while it is necessary, but it is no longer sufficient because the tax authority is empowered to go behind it and look for other information as well. But then, does 789 survive Vodafone? Does it still survive?
No, 789 does not survive. Why it does not survive, the court clearly says that circulars are to be examined in the light of the extent statutory position. If the legal position as per the statute has changed, then those circulars issued under an earlier regime will cease to be operative. The logic is that circulars are an executive or a subsidiary or a subordinate legislation, and they cannot override the provisions of the statute itself. So therefore, if the statute itself has changed, since the issue of that circular will no more be binding. And in this particular case, they said that that section 90 subsection 4 and the LOB clauses and GAR clauses have changed the legal scenario in which that circular was issued in the year 2000. 789 does not.
Thank you for the
Yeah,
clarification.
yeah, TRC survives. TRC is a valid document, but 789 making it conclusive does not serve. Does not serve.
Right. But you did refer, amongst other things, amongst the changes, legislative changes that have followed in last since 2013 onwards. You mentioned the GAR provisions, and of course, the judgment emphasizes the GAR provisions and kind of has a role to play in the whole outcome. But interestingly, I think it is the Supreme Court which invoked the GAR in this matter. Amit, what is your take on that?
Yeah. So actually, GAR is, if you see, it's a draconian provision, right? The chapter is pretty draconian. So to tackle that, legislature has inbuilt principle of natural justice at every stage for invoking GAR. So interestingly, what has happened in this case is they have without invoking chapter 10A, they have tried to interpolate the principles of GAR directly. So that is actually pretty this going to create uh, great litigation, huge litigations, because
So
this
is this,
is
sorry, go ahead, please.
yeah, because this judgment does not give the chance to the assessee to basically justify stance. What basically it says is that this can be this is a conclusively what in my reading it most in most of the places it conclusively declared this transaction as a avoidance arrangement, which is to me pretty unfair to the assessee.
Let me, I mean, take your position, and I think there is some degree of contradiction then with what Mr. Khan earlier said, because Mr. Khan began by saying very categorically, on facts, and I think he holds to that position,
Hmm.
it is a prima facie finding. So it is open to
Yes.
the SSE to go and demonstrate that it is not a sham transaction, right, Mr. Khan?
Right.
Whereas by invoking GAR, it is extrapolating all those principles. I think then somewhere a finality has been reached, is it not?
Uh, no, if you're asking me, see, the issue before the authority for advance ruling was only of prima facie, finding whether prima facie this is an avoidance. Now, all proceedings emanating from that have to be on that issue only. I mean, this
Right.
is a basic principle of jurisprudence that
Hmm.
what was there before the concerned authority that is litigated before the higher authority, same question will have to be decided by the appellate authority or the higher authority. Now, if the issue before the AR was only a prima facie finding, the Supreme Court has said so many words in the judgment itself that our finding is prima facie. What they are saying is that the legal provisions that we are laying down are such and such. So those legal principles enunciated by the Supreme Court become binding law for all of us. But on facts, I mean, I hold the position that the taxpayer, if he so wants, is free to file a tax return and claim a refund if the TDS has been deducted, and go through the entire the procedure of assessment appeal, second appeal, tribunal, high court, etc., etc. And only there the finding of avoidance will be a conclusive. Conclusive findings cannot come out of Section 245 R2, which is confined to prima facie issue.
Very well, point taken, Mr. Khan. But how do we address the point that Amit raised that Chapter 10A, the provision relating to GAR, has certain inbuilt safeguards? But here,
Right.
Supreme Court has very clearly relied on all those provisions to hold what it held eventually.
Uh, no. Again, a very fine distinction. They have referred to GAR for laying down the principles of law. They are not referred to GAR to hold that this is conclusively a tax avoidance agreement, arrangement. They've not gone that far. That little window is there. But I doubt whether the taxpayer will go into that little window because the arrangement on facts is open to question, frankly. Now, the legal principles that they are laying down are that after coming into force of GAR, an assessing officer has to look into GAR provisions also for deciding whether prima facie the arrangement is a tax avoidance device or not. Now, as far as the question of opportunity of hearing, when the final conclusion will have to arrive, before that, an opportunity of hearing has to be given. I mean, at every stage, whatever procedure is laid down in Chapter 10A will have to be followed in a regular assessment. If a regular assessment is made in this case, then the assessing officer will have to follow the procedure laid down in Chapter 10A and comply with all the safeguards built into that chapter.
Right. And Amit, I'll come back to you. Or do you want to say something? Do you want to respond to what Mr. Khan said?
No, I totally agree with him that the ratio decenti of the judgment is only that what court is saying is that they have taken a prima facie view that this is a avoidance arrangement, and it is open for the assessee to file a return and then basically get along with the assessment proceedings, which is correct. But my only concern is the tone and tenor of the findings of the court, which appears to be very conclusive. And uh, there is this principle in law that though ratio decidendi of the judgment is not a binding precedent, but there are a lot of judgments of the Supreme Court which says that even the obiter dicta of the Supreme Courts are binding on the lower authorities. So that will create a huge problem and will create a lot of litigation, I guess. And in my view, obiter dicta is obiter dicta. I mean, it has to be read it as it is, and it can't be said to be a binding precedent.
No, no, these are not omitted dicta. These are clear rationals. They have laid down clear principles. They will be binding. But
Mhm.
on determination of facts, also note please, Supreme Court is not the final authority of decision of facts. Final authority or for decision of facts is the income tax tribunal. So once the tribunal lays down the facts, even the High Court or Supreme Court cannot disturb that. I mean that is also is the settled position of law. Final fact finding authority is not Supreme Court. Final fact finding authority is the tribunal. Supreme Court is the final authority as far as questions law is concerned. So my view is that they have laid down the law. They have said that in the light of this law, on the facts already brought on record, this appears to be a prima facie case of avoidance.
As is very obvious that two eminent tax experts hold slightly differing positions, I can only imagine what will happen in real life, sir. Because, I mean, from a very practical perspective, right? Because, and unfortunately, Mr. Khan, I do see or do hear Amit when he says the tone and tenor. The tone and tenor of the judgment is at times quite straightforward, quite blunt, and quite
Yes,
direct in that sense.
I
While they
agree.
say, and you are right, the number of places they say that this is prima facie and all of that, but it could be interpreted in a
No,
different way. That's my concern.
so we have to distinguish between law and facts. On law, they are categorical. On fact, they are leaving it
Sure.
with premise.
Let me ask you a supplementary question, Mr. Khan. Here they talk about, I mean, if I read it correctly, that GAR, they talk about GAR, of course. And like you said, they talk about the principles emanating from Chapter 10A. But they also refer to JAR. How is that possible? I mean, they're talking about two things existing simultaneously.
Yes, they are saying that they can run in parallel. And I have certain reservations. See, I'll explain why. See, this concept of JAR comes from McDowell. In McDowell judgment way back, I think in 1985, the Supreme Court held that the principle of substance over form will apply to tax proceedings also, and they borrowed it from the US, from the UK tax jurisprudence, and which has been followed in the income tax department also, that substance over form. Now, in 2016, or was it 2013, when the GAR provisions were being laid down, uh, what was unwritten in the law, which was the judge-made law. I mean, this principle of substance over form was a judge-made law, which is coming from McDowell, was not part of the statute. In 2016, when guard provisions were brought in, there came a proper structure of invocation of GAR and declaring of a particular transaction or arrangement as avoidance transaction. So, I mean, on the principle that that a court is entitled to fill up a gap in a statute where there is a vacuum or there is a gap, the court can lay down a legal principle and fill up that gap. So that was all right as far as there was no guard, there was no statutory provision on the statute book relating to anti-avoidance. Once statutory provisions about anti-avoidance were brought in on the rule book, on the statute, then I suppose that the law would have supplanted the judicial principle of substance over form. Because substance over form, I mean, GAR is what? GAR is also substance over form. Only difference is that it will lay down a great deal of procedures and safeguard for invoking that substance of form theory. So to say that JAR judicially lay down anti-avoidance principles and GAR will apply simultaneously in parallel, that I mean, I have with great respect, I have slight reservations in that. But the principle remains. I mean, principle of GAR is same as principle of JAR.
Sure. That was my concern as well, or thought as well, that how can these two things work parallelly? Moving on to a slightly more, you know, real issue here, which we have seen in this judgment, is the point on grandfathering. So obviously, what we discussed briefly when I narrated the facts, that investments were made prior to 2017, whereas the actual transaction was contemplated sometimes in 2018 onwards, and that is the issue that the court has also observed. So Amit, what's your take on the grandfathering provision? Because my concern is at this time, I mean, if any transaction which has been sort of, conceptualized, planning had been done prior to 2017, but the actual exit happens post 2017, and in the context of an indirect transfer, that too, is grandfathering going to work or not?
So what the court appears to be saying is that the indirect transfers are not covered by Article 13. In fact, it will be covered under 13.4, which is a residual clause. So that's what they're saying, and therefore the grandfathering is not available to indirect transfers, and only the grandfathering which is available to the assessee is only in the cases of the permissible investments, and not in the cases where the income tax department finds that it's a avoidance agreement, avoidance arrangement. Then it won't be applicable. So this, according to me, without amending the treaty properly, it raises a huge question again. And again, it will raise a lot of litigation, according to me.
So, Mr. Khan, before you respond, and I want to actually ask you this point, and this we have also spoken offline, and the point that Amit made, that the treaty has not been amended to that extent. It is, these provisions are there in the income tax rules, 10U and so on. Now, how do we reconcile this? Because this way, lot of international investments, particularly the indirect form of investments that we are seeing here, would become subject to tax scrutiny. There will be no grandfathering. So, how do we proceed on that?
See, there are three issues on grandfather. First of all, I mean, we have been reading Article 13.3 and 13.4 incorrectly. The court has read 13.3A and 13.4 together. Now, if you go through the fine print of 13.3A, 13.3A says that gains from transfer of shares acquired on or after 1st April 2017 in a company which is resident in the partner country, that is India, will be taxable. Acquired after 1417 will be taxable.
Yeah.
Okay. So exemption is available to others which are not I mean, which are incurred before 1417, right? And 13.4 says that whatever is not there in 13(1), 2, and 3A will be taxable in the resident state. So reading these two provisions together, the court has come, and I think rightly so, that grandfathering is available only in respect of number one, residents of Mauritius. Number two, in companies invested in companies in India and before 2000. So, indirect investment in India through Singapore or other jurisdictions which are interposed, they are out of this Article 13, 13.3 and 34. So, they have read together 13.3 and 4 to come to a view that it is only those transactions which have been made by residents of Mauritius in companies in India before that cutoff date, which will be grandfathered. Now, resident Mauritius, they have gone back to Article 4, which says that the term resident in Mauritius will be determined on the basis of domestic law of Mauritius. Now, Mauritius domestic law says that a company which control and management is in Mauritius, that will be. And on that basis, they have gone back that control and management is not in Mauritius, it is in US, in the hands of a particular person in US, so therefore it is not available. That's the logic or sequence. So that's point number one. Point number two is that uh, section 11, I mean rule 11U and GAR. Now GAR provides a particular situation in which they are distinguishing between investments and arrangements. They have said that investments will be protected. Investments will not be subject to GAR, but arrangements may be subject to GAR. So arrangements are not protected. Investments are. Number three, a very basic question. And I think Justice Pardiwala's note, which is a separate note to this, that's more important on conceptual principles. That note says that every nation has a sovereign inherent right to tax incomes arising in its territorial jurisdiction. And then it says that that nation has also, that state has also the right to enter into a treaty with a with another country and allocate taxation rights or entirely or partly to that other country. Also, then it goes on that further that if an abusive transaction is entered into, then the country having original jurisdiction has also the right to make sure that the benefit of the treaty is available to a genuine transaction, not to an abusive transaction. So that's the third point on which the court has gone into, and from there they have brought in GAR and other things. So these are three issues. So all genuine investments by genuine Mauritius companies before 1/4/2017 remain grandfathered even after this judgment. But if you are not a resident in terms of the control and management, then it is not available. If it is an investment not directly into India, but by a third jurisdiction, then also it is not available. So that distinction has been made. And in fact, the court goes on very clearly in para 40. They said that the back door left open after Azadi Bachao judgment has been closed by the government by way of treaty amendment and the amendment to Section 90 and these GAR, Chapter 10. So, I mean, there is a distinction. It may be it may be harsh in some cases, but I mean, the court has taken great pain to delineate what is available, what is not available.
Sir, you cited Azadi Bachao, a very interesting point. And in fact, I have got two observations to make, and I'll also invite Amit to respond after this. First of all, you meant there is, of course, the amendment, etc., which had happened both in the Indo-Mauritius Tax Treaty. Amendment took place 2016, and there were amendments to the IT Act as well. But the one of the fundamental observations in Azadi Bachao has not been sort of either diluted or been done away with, which is to say that sovereign states have the right authority to enter into treaty and assume obligations, etc. So that is a fundamental premise. So if that be the case, now you read the very article that of the treaty that you cited, sir, Article 4, which talks about who's a resident. So there are certain characteristics mentioned there. So by that logic, these Mauritius companies, they are resident of Mauritius. But what is happening is that you are saying, are they genuinely resident or not? My question is, can an Indian court or an Indian tax assessing officer sit on judgment that whether they are genuinely resident in Mauritius or not? Isn't that supposed to be ascertained as per Mauritius legal standard?
Yes. Yes. So the Mauritius legal standard says, Mauritius definition under the Mauritius Income Tax Act of, I think, 2017, says that a company will be treated as a resident of Mauritius if its control and management is in Mauritius. Now, if you issue me a tax residency certificate saying that XY is the tax resident of Mauritius, but I find, or the facts brought in by that company itself show that it is not really resident, its control and management is outside. I mean, those are questions of fact. I mean, I'm not entering into factual dispute. But to say that a PRC by itself will be, a gospel truth and nothing, nobody can. So that will open up, wide doors for misuse of treaty, and that's what has been happening so far. So,
Okay.
and the point that I was earlier making, since the source country has a inherent sovereign right to allocate taxation rights to the business country, it also has to have the sovereign right to ensure that right allocated by it is not being misused.
Sure. So it is ultimately boils down to exercise of sovereignty and
It is,
international transaction. Amit, any
it is
observation?
absolutely it is.
Yeah, please.
Yeah.
No, it
In
is.
fact, this is yeah. In fact, this is one of the major arguments of the SSC in this case. They argued that the question whether a particular company or a person is a citizen of that country or not is basically is with the tax authorities of that country, right? In this case, Mauritius. Right? Indian authorities can't decide that whether the particular entity is a resident of that country or not. That is the basic principles of this thing, international taxation, right? So that was one of the major argument taken by by the SSE in this case, but which was apparently rejected. And on the ground that once the uh, taxing authorities of those host country finds that a particular company or a entity is not controlled there, is not basically, it's merely a conduit, then they can get into it, whether it is a resident of that country or not. That is what has been held by the courts.
And they
Great.
also they also refer to Article 27A, that is the limitation of benefit clause, which categorically says that the benefits of this treaty will not be available to conduit companies, shell companies, etc., etc. So they are referring to, I mean, to say that they are going outside treaty is not correct. The treaty itself, after amendment in 2016, has a limitation of benefit clause.
Right. I really would like to go on this thing because it is such an interesting topic, but I think we are reaching the end of our discussion. So I would request both my panelists, starting with Mr. Khan, to give not more than 30 seconds to 45 seconds summary as to what lies ahead, and then, of course, Amit.
Uh, as the court itself has said in paragraph 40, the back door left open after Azadi Bachao Andolon for misuse or abuse by entities in third countries with which we may not have tax treaties. That tax treaty benefits are given only to the genuine residents of Mauritius, not to third parties which get themselves interposed and try to obtain the benefit of Mauritius treaty will not be available. So that's the significance of this judgment, that it restricts the benefit of Mauritius treaty to genuine residents of Mauritius.
Amit?
Yes, I think as I had said earlier, the scope was very limited before Supreme Court, but they had discussed a lot of other things which were, in my view, may or may not have been relevant. But they have given findings on it, conclusive finding on it. The tone and tenor of the findings are such that it appears to be conclusive. So nobody is disputing that that Indian tax authorities can't go beyond TRC, right? In fact, in Vodafone itself, they had said that once the transaction is found to be sham, they can go beyond it, right? But what is happening in this case is, uh, without amending the treaty properly, they are going to question the whole arrangement, right? Which will severely impact the legible investments made in the country, I think. So this is going to create huge litigation, and this is not the this was only the first round according to me, and this is going to be this issue is going to be litigated a lot, and this is not a conclusive finding in my view.
Sure. So,
See,
I mean,
in general discussions, we go on, not differentiating between investment and arrangement. The code is categorical, and so is Rule 10. Investments and by FFIs are protected. That will not be touched. It is the arrangements which are in question, and that distinction will have to be, understood and applied in each and every case.
right. No, I think both the points that you made, both you and Amit, Mr. Khan, these are all extremely valid. Uh, as a transaction lawyer, I think there's an, like Amit is talking about the disputes which will obviously follow, and Mr. Khan obviously emphasized on the prima facie nature, and it is open to the SSC and what up to what level the facts can be argued before the authorities. I would want to also look a little ahead as to how do we structure international investments, particularly multi-layered, multi-jurisdictional investment, which can withstand possible scrutiny from a guard perspective, and essentially not to label the whole transaction or whole structuring as sham and an anti-avoidance, or rather an avoidance mechanism. How do we prevent all that is also going to engage the attention of lawyers and other stakeholders in the coming days, is what is my feeling about it. So, anyway, we need to conclude this discussion for the time being. So, thank you very much, Mr. Khan. Thank you, Amit, for very engaging discussion. And we would certainly see more of it in the coming days.
Just last one comment uh, for future. See, we are going to examine and investigate and read the fine print of Chapter 10A in great detail in days to come. Because the issue there is that if the transaction has a commercial substance, then it goes out of Chapter 10. So, as a transaction lawyer, I mean, making this point for you. As a transaction lawyer, if you make sure that that the transaction has a commercial substance and is not purely for the purpose of tax, then of course you are out of chapter.
Absolutely right. I mean, but again, what is a pure transactional advantage of locating my investment vehicle in Mauritius is a subjective assessment. So there could be some incidental tax benefits, etc., not disputed. But I think what this judgment is going to do is to, because as we know, a lot of such kind of structurings keep happening, and um, cons- I'm just wondering what happens to all those planning in light of this judgment. That's what is the question.
In fact,
Anyway, I think we have run
yeah,
out of time, and thank
sure.
you both
Thank
very much for this engaging
Thank you.
discussion. And we look forward to discussing this more offline. Thank you.
Sure, sure.
Thank,
Thank you.
Thank
thank
you.
Thank
you.
you, Raj.
Thank you.
Thank you, sir.